Laid this expert down, let his mind explode. Now I'm in seek and destroy mode. Every other doctor in this case observed and said surgery decompressed the nerve. Now this doc is looking weak, and that's a known fact.
Welcome to this edition of the Justice Team Podcast. Here we're going to talk about some of the sandbox regulations. We're going to talk about the future of law, the practice as we know. We're going to talk about Walmart, McDonald's coming in, Amazon law, and most importantly, what we have to be worried about as lawyers. So we have a fantastic panel today, and first led off by the wonderful Erin Joyce, who is a multiple-year state bar prosecutor and now is the guard piece for all of us lawyers. So anytime we have an issue or the state bar has a compliance issue, does compliance across the board, but is at the forefront of these non-lawyers practicing law and all these other things. We have Danny Abir, and he's from Axe Law in Encino. He has that cool little building if you're ever there on Ventura, so right on the corner. Just a bench, and he does everything, mostly a lot of bad faith stuff, personal injury. They do a lot of trial work. So, Erin, do we have to be concerned about, Amazon law coming in? I mean, how close are we to having the tech companies take over?
Well, I mean, right now you have two different task forces going forward that were initiated by the Board of Trustees after the ATO's recommendations and the 3,000 plus cascade of public comment. First, you have the Paraprofessional Working Group, which was constituted beginning of last year. They are just wrapping up their work now. In fact, Monday was a hearing, a special full task force meeting about fee caps, because they're considering, since this is all supposed to be access to justice, to have potential fee caps on these new licensees. The other part of what's going forward is the what they call the Closing the Justice Gap Working Group. This is what the basically the AI and tech companies are pushing. These are the sandbox that we talk about. We have something like that in Utah, and the one in Utah just got extended for 5 years, if you saw the headline. And a lot of the same initiatives were adopted in Arizona, and we're starting to see the effects of that. What the sandbox is looking to do in California would be to relax rules of professional conduct, particularly Rule 5.4, that would allow fee sharing with non-lawyers, read cappers, marketers, and also non-attorney ownership of law firms.
So we have also in person is going to be our color guy from Massachusetts, Adam Combies. And, Adam, you don't call them cappers there. What do they call?
They're called runners in Massachusetts.
And what does a runner do?
A runner's, as it was explained to me, very similar to a capper. And a runner is a guy you may or may not, I can't speak for myself, but you may or may not have on the payroll to drive around and try to identify potential injury clients.
Yes, I mean, Danny, you practice, you have a big firm, you're out there trying cases. I mean, what are your fears? I mean, you're pretty vocal. I've seen your articles in the Daily Journal about it.
I got a call from a newspaper in Arizona actually last week for an interview. And the reporter actually said that so far everybody has been very up on in Arizona about it. Everybody he spoke to was very positive about it. It took me literally 15 minutes for him to understand what the negatives are. And then he's like, oh my God, I didn't think about that. So the reason I'm so vocal about it is because I actually see this as the end of the practice of law as we know it, as you and I know it, and as Erin knows it, and Brian. What we are looking at is, I think, the same way taxi cabs went away with Uber, the same way Music Plus and Blockbuster went away with iTunes and Netflix. You're going to have the same thing. Tech companies have a lot of money. They have cash. They want to invest. They're in the information business, so I think a lot of what the tech companies are going to be looking for is information, basically adding to their portfolio in terms of both investments and getting information. But what they can do and what they have done is that they're going to reduce fees in the name of the consumer. Let's say if you charge 30%, they're going to say, we're going to do everything but for 15%. And or if you're doing estate planning and you charge $3,000, we'll charge $1,000. They're going to run at a loss because there's no way to run profitable at those rates. However, when you and I cannot compete with that and we go out of business, that's when they're eventually going to start creeping up their prices. I think you and I spoke about this, Bob, that Netflix came in on like $7.99 a month when it first started, and it's now $20 a month.
Yeah, they can absorb loss. I mean,
So-
they could do it for 2 years, 3 years. They don't care.
3 years comfortably. Uber is still going to get a loss. And you don't see any more cabs in LA. New York still has cabs. London has cabs. But most cities, people get on Uber. And taxi cabs are out of business. I think that's one of the biggest issues. Also, in anticipation of this podcast, I had lunch with one of my first mentors who's a partner at a Big Four accounting firm.
Is it Tom Girardi? Is that the mentor that?
I don't think Tom Girardi would know what accounting is if it hit him in the head. At least true accounting. He may know. He may think 4 + 4 = 20. But no, I had lunch with him and I said, I want to pick your brain. He's pretty high up there at Deloitte. And I said, what are you guys' thoughts? And he said, first of all, did you know that Deloitte and Touche, for example, is the largest law firm in the world? I'm like, huh? Yeah, outside of the U.S., they practice law in nearly every country. So for them, it's a natural progression if this happens. So you will have the accounting firms getting into the business. They probably will not get into the business until it's national because they're all national firms. But it is something that they can do. One of the other things is they're very efficient. So while you being an exception, Bob, most attorneys are not as efficient technologically. Someone like Deloitte and Touche or PricewaterhouseCoopers or KPMG, they can do things in ways that most law firms cannot. And they'll be very efficient. And they may not run at a loss, but they'll still be running at a cost point that you and I or most people cannot run at a profit. So you don't just have the technology companies and investment banks and Costco and Walmart. You also have the Big Four accounting firms who are giants in terms of practice of law across the world.
Well, Erin, how did we get here? So how did it become on the State Bar's radar? You know, I heard they tried this in Washington a while ago, didn't work out too well. How did it get here where they're saying, hey, we got to protect consumers, maybe from those greedy trial lawyers, right? I mean, how did this get in front of the State Bar and who's really pushing the agenda?
You'll probably know, and I would, because I was the last hire before Pete Wilson vetoed the FEBA in the 90s. So I've been acutely aware the whole time I was at the State Bar that it's first and foremost a political agency. And pretty much since the late 90s and maybe even before that, there was always the specter of deunification. And that happened. That happened as of 2018. The sections have been, lopped off. That's what's left now is California Lawyers Association, a voluntary organization. And what is now remains as the State Bar is supposed to be solely a public protection agency, discipline and admissions. But part of their mission statement says to advantage access to justice and diversity in the profession. And it's on that portion of their mission statement about access to justice that the State Bar is basically moving toward allowing many other ways of delivering legal services other than just through lawyers, their licensees. And the State Bar is funded entirely by licensing fees. There's no part of the state budget that supports the State Bar. However, they live and die if they get a fee bill passed every year. That Senator Umberg just very recently put out on the Senate floor, or is moving out of the Senate, a bill which is going to prevent the State Bar from collecting anything but the statutory portion of the licensing fee, which is part of CSF, Client Security Fund thing, about $43. Nothing else until they have a chief trial counsel that has been voted on by the Senate. Because for the last 2+ years, the State Bar has thumbed its nose of the statutory obligation to have a chief trial counsel and answerable to the legislature. You have a holdover interim sitting in that position for more than 2 years. They don't even have a solid executive director because they terminated the executive director a year and a half ago with the last fiasco with the bar exam. Her son happened to sit for the bar exam at the same time as Leah Wilson. Her son took the bar exam at the same time that the 16 topics for the essays were released early, if you'll recall. That was in 2019. And so she's no longer executive director, but guess what? Guess who's shepherding through all these working groups as a consultant with her salary not being disclosed?
Well, but who's the state bar?
Right now.
Where does the state bar's power derive? Like, who do they have to answer to? Let's say it goes through these working groups. I mean, what's the next step? Could be challenged?
Well, this is the thing. I've been listening in on these working groups, and they think most of these initiatives that they're planning will go by rule of court and changes to the rules of professional conduct, which have to be adopted by the Judicial Council. So they think that it's going to take very little in the legislature to get through most of what they want to do. I think the answer is a legislative solution, because this is not going to help California consumers. They're basically gutting the consumer protections of the last 50 years for people that are out there without experience looking for help.
I mean, let's be real. If this goes to a proposition and there's so much tech money behind it to influence the consumer to say this is good for them, they're going to vote for it. There's so much money behind it. So where's the money coming from? Danny, Erin, do you know who's the one that's funding all this? Who wants to get into the legal space?
They're all legal tech people. They either work for large firms that have Google as one of their main clients. Seriously, that's not a joke. They all have ties to legal tech. That's the truth. It's a stacked deck, both on the Closing the Justice Gap working group and on the Paraprofessional working group. It was not a question. It's basically they already had a decision and they're just pushing it through.
So Adam, we had this discussion on the car ride here, talking about law firms going public.
I mean, as soon as the floodgates, so to speak, open and you've got the big four accounting firms involved, there's going to be a rush to capitalize in order to survive. And the way the markets are now, there's a lot of cash out there looking, investable cash, dry powder, looking to get it invested in, something like a large law firm might be a good place to put some cash with expected growth. And it's a great place for a large law firm to increase their coffers, take on some shareholders, and all of a sudden we have, K&L Gates on the S&P 500 or whatever it may be. But, those who are able to take advantage of it at the beginning will likely, succeed, and everybody else is going to get left behind.
So it's going to be like shifting to like the big four conferences, the other ones are left behind type deal.
Sure. And I think that as much as Danny was talking about the big four getting involved, I don't know that they would go after our business on the plaintiff side. I think it's more offering services to their existing clients, but now instead of just auditing and the public accounting functions, they can throw in some legal services with the package. So as far as the big four, those companies getting involved, I see that more as undercutting big law.
Yeah. No, what I meant by the big four wasn't getting into the PI business. That's not what I mean. The conversation I'm looking at is law in general, or the practice of law in general is going to change as a result of it. Our practice, I think, will be impacted the most from the big tech companies or Googles of the world. Google already controls how you obtain your cases. I mean, the advertising and everything that you do is online. So imagine they not only control the source of the cases, but they actually give the source or get the cases to themselves. Not that there's anything against that legally, but that will pretty much make it almost impossible for anybody else to be able to get cases. I mean, you can argue they have a monopoly, but they really don't. But not from a legal point of view. But they will be able to control both sources, the work and getting the cases. So I think that's probably what is most dangerous for our practices as plaintiffs lawyers, Big Four I see more as hourly or basically engagement type work, potentially doing litigation, but not contingency work.
Yeah. So, Erin, when you were at the state bar as a prosecutor, and now we see these tech companies coming in. What are they using as examples of, if they are they using like the billboard lawyers or the lawyers that ripped off their clients? I mean, what are the examples that they're putting out there?
This is one of the things. This is all being ushered in as a solution for access to justice. Basically, the people that are otherwise, at Stanley Mosque on the 4th floor, waiting when they were allowed to do that, to get into the self-help clinic because they have like half a day unlawful detainer, half a day family law. Or people that are, qualify for public counsel or neighborhood legal services, anything like that. However, all of the legal services organizations are without question against these proposals. Because what's going to happen is it's going to siphon away monies that would be invested for legal services, quality legal services for the poor. Instead, there's going to be a 2-tier justice system, to the extent there's any, where there'll be, people that can't afford real legal services will be shunted off to either paraprofessionals or basically their divorce on their on their phone, like Hello Divorce. Basically, it says if you answer some questions, they can fill out all your paperwork and get it filed for you. Seriously, it already exists.
Devil's advocate, how's that not helpful for the consumer?
What happens when you get your estate plan or you get your family law paperwork spit out? And even selecting the right forms is the practice of law, certainly under Business and Professions Code 6125 and 26. I can't figure out anything, no matter how many times I watch a YouTube video, how if my car's making a knocking noise, what's going on. I don't spend any time doing that. But a lot of people think, they could read something from Nolo or read some blogs, and all of a sudden now they're ready to do their divorce. Great. But now what happens at the end when they don't get the child support they need? Or worse, you got the computer to spit out your estate plan, and now decedent is dead, but all the beneficiaries are living with the aftermath. And if you get a document right now prepared by LegalZoom, there are disclaimers and there are limits of liability that if you tried to put anything like that in your fee agreement, you'd be engaged in unethical conduct and be subject to discipline. I literally was at one of the ACHIL's meeting when we're one of these legal tech people, and they don't know anything about the practice of law. They know as much about the practice of law as I do about the car engine. And they're like, hey, well, if one of these corporations that practices law does something improper in court, they could just issue terminating sanctions. That's what this person said with a straight face, because they don't know any better. They don't even know how foolish what they're saying sounds. And by the way, sunset law one day, sunrise law next. There's no reputation need there. But if you've gone invested to your undergrad, your 3 years of law school, the most important thing that a service industry person has, a lawyer has, is the reputation, right? It's your reputation that brings more clients in.
I think there was a new professions code that pretty much said, hey, you got to get on top of technology. I think it just came out this year. As a lawyer, you have to invest and see what the best source of technology is, essentially, so you don't absorb the overhead. But don't we see this trend in that direction? I mean, should we have a forced evolution of the practice of law in general, and then maybe we wouldn't be here? I mean, Danny talked about efficiency. I mean, Danny, you have an efficient firm. I mean, do you think that if these things start to change, if people don't evolve, they're just going to get run through the sawmill?
I actually think in some ways you're going to have that anyway. I mean, you and I talked about different vendors that can actually save you so much time in your practice, or different softwares or different things. I think the next generation of lawyers are going to have so much more at their fingertips and so much more technology that can help them become more efficient. I also think that part of our background, as far as lawyers are concerned, most lawyers' backgrounds are liberal arts. So they're not business, they don't have that business savvy or business courses that when they get out of law school. Same thing with technology. So I think we're kind of hindered in that way, if that makes any sense. So some firms are actually going to be able to thrive. And I think with time, you're going to have some firms going to go away, but I think that goes to the efficiency of your firm. That doesn't go away to what you're doing for the consumer. I mean, you may have a lawyer who may not know how to use, how to view a video on YouTube, but be a damn good trial lawyer and be a good litigator. I don't think that takes away access to justice. It makes them less efficient.
So what happens if, this paraprofessional or someone that's a non-lawyer, what if they commit malpractice? What's the recourse? Who bears that burden, Erin? Who has to pay for that malpractice issue?
I was at the meeting when they talked about that. And, the state bar was smarting and stinging from their, failed efforts to force all lawyers to maintain, a particular errors and omissions insurance, a la Oregon. And they lost. So now what the compromise is that in your fee agreement, if you don't maintain errors and omissions insurance, you have to disclose that. So at the meeting discussing this issue with respect to these paraprofessionals, the discussion was, why should the burden be any more on those paraprofessionals to maintain errors and omissions since lawyers don't have to maintain it?
Who has to pay when they screw up? Somebody without a license or training, who has to pay when they screw up? The consumer does in that scenario, if there's no errors and omissions insurance.
The consumer is going to be gutted. That's right. They don't. This is so clearly not about access to justice, because in some of the meetings they've been talking about, we're not here about those people in the line at public counsel because they can't afford fees of any level, right? The only way they can have attorney's fees or attorney's services is if it's free, because they don't have money. This is a grab for the middle class legal market, unabashedly, and it's come out during their meetings.
So, Danny, how can lawyers or law firms or small firms, how can they insulate themselves to protect themselves if and when this ever were to happen?
And it's funny. It's a question that I've been asked quite a few times. The only solution I can think of, actually, there are a couple. One is to try to get as many cases as you can until it happens, so that you've built a nest egg, and then at that point you can kind of look at your options and see where the world is going. Or you can join Amazon and become an Amazon lawyer. But the alternative is something like your Justice HQ, or groups of lawyers who work together and kind of can band together into one entity, not necessarily a partnership, but kind of like a joint venture of lawyers who become large enough that will be able to combat at least some of these giants to some extent. But reality of it, I think, is if this does happen, very, very much like what you said, I don't know if it's something that we'll be able to have the financial wherewithal to fight. Look at us in California. We haven't been able to get rid of MICRA for eons. Because we can't combat that. Just imagine how much money will be behind this one if it became something that people voted on.
Erin, you're there for these discussions. Danny, you're there for some of them. What are some of the things that are the hard no's for paraprofessionals or for non-lawyers? Is it trial, litigation? Like, what are the ones where people are like, yeah, we're not going to touch that space, if anything?
Oh, no, there is. That the default position is that full in-court representation in all areas that will be agreed, meaning the subject matter areas, carving out jury trials. That's it. So think about it this way. If you're a family law practitioner at this point, family law doesn't have jury trials. So pretty much the person across the aisle very likely may be a paraprofessional in the future, not too far away. More than that, I was at the meeting where they were talking about regulation and discipline, which is, of course, an area that I'm really interested in. How about this? Firm of Smith and Jones. Smith is a lawyer. Jones is a paraprofessional. And then the discussion was about, because they have redlined version of the paraprofessional rules of professional conduct. Kid you not. Greg Fortescue, who is one of the lawyers for the Chief Justice, is the one leading the charge on this, by the way. And basically, they think in 2 meetings, they can adopt a completely new set of rules of professional conduct for these paraprofessionals. And in the context of that, they're talking about, well, we're going to have to change Rule 7.1 because, we can't be misleading. That's right. No ad misleading. But maybe it's not really misleading because it doesn't say they're both lawyers, Smith and Jones, right? It doesn't. So, it was pretty appalling. Another thing you should think about is they actually hired a professional, a naming professional, because they were getting the idea that paraprofessional just doesn't roll off the tongue well enough. So they're thinking of other names to call this entity. And we know triple LT doesn't work. That's what died in Washington State.
How about a squire? That'd be good, like a squire.
Esquire, yeah. How about this? This is a real one. Advocate.
Oh no.
I've prosecuted non-lawyers as advocates. That is unauthorized practice of law, because the normal person hears advocate, it's a damn lawyer. Yes, it is. That's one of their options that they're going to vote on. I think that's not going to pass now.
I hope
that out.
So let's talk. I'm just talking about some new, where the practice of law may evolve to. We're talking about tech companies, and Adam and I were talking about some weird stuff on the right here. Like, what about having like a cryptocurrency or an NFT for law firms, right? I mean, Danny, if you looked at this, because you are a very forward-thinking guy, I mean, if you thought at all about having something just so outlier that's like, oh man, shit, we should probably do that. That sounds so interesting.
It's so funny you say that. It's trying to think innovatively and try to come up with different ways of doing things. I mean, you look at some of these cryptocurrencies like doggy coin or something like that started as a joke. And now you have, what's his name, Cuban, holding like 3,000 shares of it, of something that is nothing, basically. So if that's the case, we can have a California Bar or a U.S. American Bar Association cryptocurrency that basically we can pay our employees with it. Think about it that way.
So Erin and Danny, I think, they had a lot of talk about estate planning, right, for the paraprofessional. So, give our listeners and viewers of watching on YouTube right now just an idea of who they're coming after.
Family law, we all know if you've been in, pretty much any court, you're going to see family law is just overflowing with pro pers, people that really need relief and they can't afford lawyers. So certainly most family law representations are part of what's being considered. There actually was a lot of pushback with respect to the area of probate and estate planning because of the, major harm that can be done for the decedent and their family. And also it's a very complicated area, very statutory. So I don't think most probate is being considered as part of the areas that can be allowed. Some consumer law, like when you're dealing with a credit card, a case involving a credit card, looking for collections, things like that. Employment, it's like it will not die. Every time it comes up there, they've carved out most of the employment, except for I think representation when it's a situation where you're before EDD, those kind of claims. But definitely the people on the working group want employment to be in. And that's why they just won't let it be over. Leah Wilson's leading the charge to get employment brought back in. And I'm sure you've probably heard Jeannie Harrison talking about how, every time it's come up in the different subcommittee groups, they've been basically carved it out to very small areas of employment. Because again, major rights are being abrogated here. And there is a huge power differential between employer and employee, which is not going to be advantaged when you have a paraprofessional representing the employee. Well, and if there's a valuable case, there are plenty of lawyers that'll take it on a contingency. So there's no access to justice issue there at all.
But if that paraprofessional now works for a giant legal corporation, then there has to be some inherent conflicts there too, because how can you successfully or truly advocate for somebody if you're really just part of the problem, this giant corporation that's now in the legal services business? I mean, you're an employer yourself.
So you have runners, we call them cappers here, but if we open this up to the non-lawyers owning law firms or profit sharing, aren't we just giving a get out of jail free card, or here, have free reign for runners? And
it's a carte blanche completely to anybody who wants to go try to get a case. I mean, what prevents us right now, at least some of us, present company excluded, from sending somebody to the hospital and getting a retainer signed right then and there is rules of professional conduct. If you have a paraprofessional or an advocate doing this, there's nothing that's going to prevent them from doing that.
Yeah, but don't you think some of these, I mean, what if Google just employed a bunch of, I don't know, ambulance drivers that could also be on payroll for Google and got a bonus every time they brought Google a case? I mean, this is a slippery slope, but if these are the red lines, they could do it. I mean, Erin, you've seen the red lines. They could do something like that if they wanted to.
Well, I think the bigger concern is going to be when you basically take all of the rules of, away for legal advertising, which is a lot of what they're trying to do also. They're trying to relax the already very liberal advertising rules. Instead of being access to justice like you and I think of, which are those people that are the pro pers that can't afford a lawyer and they have a legal problem. They talk about how many people, based on their survey results, didn't even recognize they had a legal problem in the first place. They thought they either had bad luck, a bad boss, or circumstances. And so they didn't look for a legal solution. So they want to be able to heavily advertise and they want to be able to directly solicit. Because right now you could send targeted like direct mail to potential, leads. You can, but you can't phone call them and you can't show up at the hospital, just like Danny just said. However, what happens if you can start Facebook messengering them directly? What happens if you can start text messaging them directly? Right now, Rule of Professional Conduct 7.3 stops you. But we have a bunch of companies that are already operating in the at least gray area.
Yeah, and other people that are direct targeting messages and servers that as soon as something happens, they shotgun it all. Hey, I'm friends with your cousin. Hey, what's up? Right? So, I mean, have we thought about what if you went to the people behind all this and say, look, if you want to be in this space, this advertising space, if you're a non-lawyer in a law firm, what if we just capped you, you get a referral fee of, say, 10%. You can take the advertising space, take the 10%, but you're not allowed to litigate and try cases, and you have to have this set percentage. Like if we thought about, look, if this is coming, why don't we just try to limit what they're able to do? I mean, let's be honest, a lot of the advertisers that are out there are bad. They're bad for us. Some are good, but a lot of them are doing very bad things. So how do we solve that problem and this one at the same time? Can we have a negotiation?
Well, like I said, what's already over the line right now is going to be permitted under the rule changes that are being proposed. They are. That's going to be allowed.
Oh my God.
And why would they share that case with you? They don't plan on litigating it. They're just going to get 50 cents on the dollar and keep all of their, you know what I'm saying? They're going to maximize their recovery, not the client's recovery. And that's a large reason why we can't, I think Danny already said this, but it cannot be said enough. The rules of professional conduct are not there to protect lawyers. They're there to protect clients. Because if you, like you said, if we have a shareholder interest in my law firm, then my direct loyalty to my client is infringed, right? I'm concerned about the short-term gains of my stockholders rather than long-term needs of my client to get the case fully litigated to get the maximized value out of the case. So you're going to be compromising that. That should be an undivided duty of loyalty to the client when you start having non-attorney interests involved in the decision-making.
So Danny, can we defund the state bar?
You know what? It's so funny you say that. How far does this reach? I mean, who listens to this podcast?
This will go to anybody that wants to go to iTunes and all that on YouTube. So look, if you don't want to say it.
I actually, when some of the issues have come up, that the state bar was supposed to protect the consumer, I've thought, why is the state bar immune from liability when their job is to actually protect the consumer? But you can't sue the state bar for basically neglect of what they're supposed to do. So forget that. Now they're actually going the other way. They're doing something that's going to put us out of business, put the same people who are paying their dues out of business, and they won't be able to survive. So I don't understand what's the point of funding the state bar right now.
Why can't we as lawyers band together and file a lawsuit against the state bar for not protecting your interests or paying dues and licensing fees too?
So good question. The lawsuit that I thought about was suing on behalf of clients of attorneys who the state bar should have disbarred long ago. Okay, based on the facts that they had and for whatever reason, they turned a blind eye to it, or we know what the reasons are. That was my thought, and I thought that there should be a lawsuit filed for that. And when I looked into it, they said that they're immune and you can't do that. Now, whether they're immune from the lawyers who are paying their dues or the members for them violating what they're supposed to be paid to do to protect them, that's a good question. But I still think you're gonna have the same issue, because they're going to say their mandate is to protect the consumer and the clients, not the attorneys, which is correct. But they're not doing that either.
That's the whole thing. Is that, in my opinion, look, I don't care who's listening. The state bar is a joke. Come look at the stuff I'm doing. It's fine. We're not doing anything improper. But come and look at me. Look at the people that are doing things you know are improper, fail to do anything, and then use that as a scapegoat to say we need this other tech money to come in to clean it up. I mean, they're not doing anything. So who gives the state bar their power? Can that power be revoked? Does it go to, is it the Judicial Council? Can it be the judiciary that Senator Umberg is currently the chair of? Who gives them their power?
It's like they had a 1-2 punch, because you had the state auditor come in, and there's never a good audit for the state bar. I mean, really. But this last audit was probably the worst I've ever read. And boy, was it fun. Because in 2015, the state bar, with their last chief trial counsel, adopted a bunch of reforms. And based on their reforms from 2015, in the time period from the audit from 2015 through 2019, their backlog increased over 87%, and their case handling time more than doubled with their reforms. Seriously. And that doesn't even include the fact, and I did this myself, I crunched the numbers, in 2018, which is the last time you can actually get this right off the website of the state bar based on the results, the cases handled on the merits in the state bar court, more than 20% of the cases were full dismissals of all charges against the lawyers. And that hasn't changed. That is, they are filing garbage nonsense cases against lawyers. And this is what they'll tell you, because I've been there. I hear it. Guess what? If we one count out of 11, 13 counts of nonsense, we get all of our disciplinary costs. And a multi-day trial is going to cost a lawyer $23,000 and change, disciplinary costs. So they try to extort you into settling for discipline that you don't deserve. And I just had a case that got dismissed right as soon as the state bar closed their case, the judge kicked them in the teeth and closed the case. I'm waiting for the formal decision, but we already have a minute order. Full dismissal. They charged him with a violation of conflict of interest, and as they always do, they added moral turpitude. Now, you and I think moral turpitude should mean something, but in state bar practice, it's just a bargaining chip, because it lets them, under the standards, seek substantially more discipline, and they use it saying, hey, you're going to have to bite on a moral turpitude charge. And they offered my client 6-month actual suspension, an over 20-year lawyer that did nothing wrong. He had to go to trial. Wow. And that's not an aberrant case. That's happening all the time in the state bar court right now. Any other prosecuting agency that had as bad of results as they do would have repercussions to pay. And so first you get the state audit report out, and then you have Senator Unberg, ushering out his bill saying you're not going to get any money until you have a new direction out of the chief trial counsel's office. And that is what's necessary, because the whole state bar is a long way right off the cliff and taking the profession with it.
So Erin, what if your client, that 20-year lawyer, hired a paraprofessional to handle their case instead of you? They probably would have got disbarred.
In November 2019, the Board of Trustees got a report, and it was a survey of results from disciplinary proceedings, investigations, and proceedings in state bar court. And this is what the report says, not a joke. Everything being equal, when an respondent attorney is represented by counsel, the handling times of the matter and the results are significantly better for the respondent attorney. And if you're a solo practitioner, if you're a minority, your results are substantially worse.
That's crazy.
Black male lawyers, percentage of the population of lawyers in California, they're disproportionately large percentage of the disbarments. So this is what's happening. The state bar goes after what they call low-hanging fruit, easy marks. And if you're a hard mark, if you're a big time lawyer, if you're a big firm lawyer, if you're a government lawyer, you pretty much have a pass. That's just a fact. But if you're a small person, small time lawyer trying to make your own living, they're going to go after you with all their guns because they're just looking for the mark. They just want to get their stat. And unfortunately, and they have very, very limited understanding of the discipline laws themselves. The case that went to trial, we had a report of one of the professors who was on both the first and the second rules revisions committees to explain to them that they're misreading the conflict rule, literally misreading it. This is their position. Joke not. If an attorney provides a referral to an active client, to a family member or a friend, you need informed written consent. That's it.
What?
So you can't make any referrals to your active clients, according to the state bar, without informed written consent. Not a chiropractor, not a doctor, not a litigation funding loan company, with no other facts of a kickback, consideration, or anything. They tried that case, guys, and they still believe that.
Oh my God. I want everybody to repeat one mantra before we go. Disbar the bar. That's disbar the bar. We'll defund the bar till they clean up their act. But everybody, thank you for coming on. Any questions, media@justicesteam.com. Thank you for listening. Thank you for watching if you're on the YouTube channel or wherever else this is on these days. I want to thank Adam for coming in live from Massachusetts. He's not so tech savvy, so he came in person rather on virtual. So we're happy to have him. Thanks everybody coming on. Remember, no sleep till justice. Thank you, everybody.
Laid this expert down, let his mind explode. Now I'm in seek and destroy mode. Every other doctor in this case observed and said surgery decompressed the nerve. Now this doc is looking weak, and that's a known fact.